4557, is that correct?
That's correct, Chairman.
Okay, go ahead.
Mr. Chairman, Madam Vice Chair, members of the committee, my name is Jack Walker. I'm the Vice President of Legislative Affairs for the Texas Trial Lawyers Association. I'm here to testify against House Bill 4557. First of all, I want to thank Representative Darby for meeting with us to discuss our concerns about the bill. We are committed to work with Representative Darby to address some of the issues that I'm going to talk to you about today. I want to start by saying this. Captured carbon dioxide is a good thing, and we are in favor of all efforts to combat global warming and the effects of excess CO2 in our environment, but we must all insist that these efforts be conducted safely and not in a manner that could cause more harm than good. This bill seeks to limit causes of action and damages available to injured parties and landowners who are or could be damaged by carbon captured dioxide activities. First, we need to understand what we mean by captured CO2. It's not CO2 in the traditional sense of the word. This bill defines carbon dioxide very broadly. It's not simply a carbon atom combined with 2 atoms of oxygen. It goes beyond that. The definition of CO2 in the bill includes phases, mixtures, and combinations of carbon dioxide that include substance incidentally derived from the source and substance added to the carbon dioxide stream to enable or improve storage. This is going to include substances like benzene, toluene, xylene, and every other dangerous material in the carbon chain of petrochemical production. The process of capturing and storing CO2 is relatively new, as admitted here today. This is a new industry. It's dangerous to grant upfront immunity to an industry where we don't fully understand the scope of the potential liability. One of the stated goals of this bill is to place limitations on non-economic damages, but not actual damages. However, the bill specifically eliminates nuisance claims by stating a person may not bring a nuisance action or similar cause of action on the basis of capturing and storing CO2. I'm going to revisit an argument or a statement I made before in the nuisance bill. Nuisance is not a cause of action per se. It's an injury. So there's confusion in the bill. Therefore, it's confusion by saying we don't bring a nuisance cause of action. It is an injury. The damages available for the injury of nuisance include economic damages, the cost of cleanup, the cost to abate, the cost of future injuries, future harms. These are all economic damages that the bill purports not to address or not to eliminate. But if you eliminate the injury, you take away the ability to recover the damage. In this case, potential significant economic damages. The second point I want to make is transport. The transport of CO2 during the process of capturing and storing carbon dioxide. The definition of a defendant is overly broad, as it includes not only the process of storing CO2, but extends the protection of the statute to transport of CO2 to the storage facility, whether it be by pipeline, truck, train, or boat. Remember, we're talking about potentially dangerous materials, and the materials that we're talking about have the greatest potential to cause injury during the transport process, not when they're stored, but when they're being transported. And while we would grant immunity to those in the transport process and then take away their rights for cause of action. Mr. Chairman, I'll end my testimony there and take any questions.
Okay. All right. Thank you, Jack. Members, any questions? Okay.